name is Kenneth Akampurira, a partner at Amber Advocates. I am an insolvency practitioner. I'm also an arbitrator and a member of the Chartered Institute of Arbitrators of the UK. I'm the honorary secretary of the Chartered Institute of Arbitrators of the UK Uganda chapter. It's a new baby on the block. I've been asked to talk about legal lifelines, alternatives to closing shop. I want to take it differently. Normally, I prefer to start with a quote, and I'll quote about a budget, because one of the aspects that a business thrives on is having its budget in order. So a budget is telling your money where to go instead of wondering where it went. That is John Maxwell. And that, in my view, links with our topic today. And I'll start with the topic itself is legal lifelines for SMEs, alternatives to closing shop. I want to tweak it a bit and add what is in red there, what to do to avoid closing shop. I think all of us will appreciate that closing shop is normally affiliated to debt, being unable to meet your expenses, or your liabilities exceeding your assets, and your cash flow being unable to meet your daily running expenses. So in that regard, I want to talk about debt, and most of us borrow. So normally we close shop because we've been able to pay our debts, or we have borrowed and the bank is on our case, or the money lender is on our case. The quickest option is to close shop and say, let me abandon this ship. Okay, so I've made assumptions. So assumption number one is both small and big enterprises will ordinarily close shop because of the following. Number one, liquidity challenges. That is not a legal issue. It's non-legal, but it's tied into the operations of the entity. Unpaid or delayed creditors, which is related to liquidity. That is a legal issue. No, it exposes you to legal liability. And the lack of capital to match competition, hence being kicked out of the market. That is still a non-legal issue, but it could result into you being exposed because you have competitors who have come into the market. You've definitely run out of cash flow. You've run out of sales. It is obvious that you have no money to pay your liabilities. Technology, the market changes, for example, COVID-19, introduction of Zoom, Google Meets, and the like. Hotels have now had challenges on renting out their rooms for meetings, because people can now convene meetings just like today on Google. So cash flow challenges are likely to arise in such industries, especially hospitality. The other is printing industry, where people now can exchange PowerPoints and even printed pamphlets for the training online. So people do not need to go down to NASA Road to print anymore. So challenges of running out of business are very possible or are very likely. Death of a proprietor. As you will note, most of our entities in Uganda are borne by families or by a single individual or two individuals with different strengths. The likelihood of closure is high. This is a non-legal exposure. In my view, things have happened, people have died, so you can't do much. The entity has to close if you're the sole proprietor. And many other aspects could arise that leads to closing of your shop or closing of business. I will now move to the next slide. Assumption number two, which entity or legal personality is likely to close shop? I'm looking at two entities here. I'm looking at a company that is incorporated or registered under our Companies Act or the laws of Uganda. These are mainly trading companies involved in trade or manufacturing. The others are trading entities engaged in the service industry. For example, the hospitality industry, that is hospitals, hotels, etc. The other entities are education services, schools and institutions. And I've chosen this for a reason, because we have dealt with most of these particular entities in trying to mainly either in insolvency or trying to advise on how to get out of the pit hole that they're in terms of debt. The other entity, which I think some people on this meeting this morning are sole proprietors. They're also known as registered business names or registered business name. These are sole proprietors or even partnerships, where people are in partnership, but they're not incorporated as a company. So we have family businesses, for example, Evans and Sons. We have restaurants. We have Alinda Mukama and Daughters Enterprises. These are entities that are likely to run into financial disruptions, hence closing shop. We will definitely move to a case study, which will help us to appreciate better how the entities look like, especially in Uganda. Those that we have dealt with, I speak from those that I have dealt with. I might have dealt with others that are unique, but this is a common or typical scenario. Okay, so scenario one, Evans and Sons is an enterprise engaged in the business of manufacturing local made shoes, commonly known as Nigina. He runs the enterprise together with his wife and 2 sons. Evans and his wife retired from Bata Shoe Company and started their own business of making low-end shoes, which are a fast-moving item in the suburbs of Kampala, that is Kawempe, Wabigalo, Chimombasa, and Owino. After 3 years being in business, their product has become known and they are unable to match the demand. The 2 sons, I will not mention their names, but they are known, are graduates of business administration from MOOPS. They advise Evans, who's their father, to approach the bank for a leasing facility to purchase new machinery. The bank grants the facility for 36 months, that is 3 years, and production increases and sales skyrocket. So there's an excitement normally when things happen, owing to your advice as a son, but you do not know what will befall you in the next few months. So after 1 year of performing on the lease facility, a new Chinese company comes into the market with the same product, this time offering a variety of colors. Evans and Sons were producing only black Niginas. So customers now have a choice to choose from, and the shoes are even cheaper by 20%. I guess you can all guess what happens next. So scenario one still continued. What has happened to Evans and Sons sales? Sales nosedive. That is obvious because the competition has now become stiff. There's a better product on the market. Defaults have arisen on the 2 installments. He is now in 60 days arrears. Please note that Evans and the wife have never been served with a demand and the threat to repossess the leased machinery. I should have added even the premises being closed and their personal guarantees being called in.
They have never, or they have been served?
They have never been served.
Oh, okay.
So in other words, there's panic now in the house for the first time. So there's panic. People are seeing letters that have those last lines that say, if you do not pay within 14 days, we shall have no any other option but to engage all the legal machinery available, or appoint our external debt collectors who shall not spare you. So those kind of words are normally threatening. You may have high blood pressure shooting up. Common mistakes or advice from friends. So Evans and Sons are told to consult his friends immediately. And the friends who've been in business longer, especially in areas of Owino, Chikubo, will tell them shift from the premises and hide the machinery. Or don't worry, the bank will not do anything. The machine is old. Give up. Others will give up. Others have a mentality of we shall cross the road when we get there. If I'm to use vernacular. Pray or consult Mama Fina. So this is the kind of advice that people will give many of us in our businesses when things go hayway in terms of liability. And this is very common, I think, in the SMEs or even the informal sector itself. When you've dealt with some credit, with some data, they'll tell you, I thought this thing would go away. I thought the bank would never find me. I waited for them to come. Others will say, I prayed and waited for a miracle. Unfortunately, it may not happen. So the reality is, beware that this debt will grow from a cub to a lion and will eat you. The bank or the lender will not stop haunting you. The debt will not go away by visiting spiritualists. So you need to deal with it. So this is your problem. It will eat you. If you don't deal with it, it will still eat you. So the eating is the closing of shop. Closing of shop also includes being arrested, being sent to your prison if you're the proprietor. And if you have assets, they might be sold off by the bank or by the lender. Way out for Evans. So we refer back to our scenario and how to deal with this situation. My opinion is it is time to seek expert help. When you find yourself in such a scenario, it's time to seek expert help. But before we even get to the point where you're seeking for expert help, when you're actually in their need of the help in terms of liabilities are on your door, people are knocking, the bank wants to take the business, it is important that even before you engage into the debt or even securing any debt, you first engage an expert to help you appreciate the kind of debt that you're jumping into. So it is time to engage your accountant, organize your books, to look at the account receivables, and also preparing a cash flow analysis. You need to establish whether you're able to match the loan or debt with the current revenue and projections. If at the time of securing the loan you had engaged an accountant, or if Evans had engaged an accountant, it would be easier for him to project and know, okay, fine, I think I have the following, I think my cash flows look this way. I'm able to eat a debt this big. I'm able to make a repayment this big. Unfortunately, when businesses look good, we walk into banks or to money lenders without even matching any cash flow to repay that loan, which is monthly normally. Others are quarterly. And unfortunately, it is late when you come to a lawyer or even to an accountant for him to advise you. But if you're in 60 days arrears or 30 days arrears, it is important that you run quickly to your accountant so that you begin looking at your numbers critically. All businesses thrive on debt and they also give debt. So it's important to look out for your account receivables. Are there systems in place on your part in terms of, do you age your debts? Do you collect after 45 days? If you're supplying, for example, Carrefour, Niginas, are you looking at the shelf life of your repayment or of your payment from Carrefour? Normally, supermarkets give a 30 to 45 days credit. So in other words, you must tag your payments on the repayments that you expect. Otherwise, your lender or your creditor will be on your neck because you did not match your revenues or your sales with your repayments. So it's important to engage your accountant. If there are any debts outstanding out there, you start collecting them. How long do you give people credit? It's very important to age your credit as well as an SME, to know that I give you my shoes, but you must pay within 20 days if you're selling them, especially those who are doing wholesale. For the account receivables, it is also time to aggressively collect from your debtors. So engage an expert, that is a lawyer or a debt collecting firm, collect at a success fee or at a percentage. I'm putting this aspect of success fee or a percentage for reason that you also need to manage your cash flow. The Indians have a saying that you cannot chase bad money with good money. So in other words, your debt collector should be able to at least collect and earn a success fee upon collection or earn a percentage from the collection made. So success fee can be agreed. I can give an example. We used to represent a client, an Asian, who gave us a success fee of 1 million per account that he gave us. And for us, it was cash flow. Because if I have to chase around 10 files and I'm successful, that is 10 million shillings without negotiating. So those are the catches that you can put for the expert, especially those in debt collection. There should be a success. Now they should be driven to chase the money or to chase the collection. This helps you in managing your cash flow and also for you to be able to pay off your debts. Many enterprises come to the experts when it's too late, when the account receivables or that they gave their products have disappeared from the market, have shifted from where they used to be. Pushing sales is good, but also receiving cash is key. So I know that also cash is king in the market. So you must push the sales and also collect. So if you do not collect, the liability is likely to come on your door. You're unable to pay your lease facility or your loan facility. So key financial documents that will be analyzed at this stage if you run to a professional, for example, an accountant. It is very clear that the bank statements will be reconciled. You will not have to jump into the battle of fighting after 60 days or 90 days of being in arrears and you're reconciling accounts. If the accountant is engaged immediately, you will definitely know what your current account looks like, what your loan statement looks like. It's also easy for you to get these statements when you're not at recovery stage, when the lender is at your door saying, I'm closing. Getting information from a lender is very difficult at that stage. So this is the time when you're in 30 days arrears or 60 days arrears to ask for your bank statement so that you can reconcile with your accountant on what money went off if you had made earlier payments. And then also looking at your loan statement to establish what is your indebtedness to the bank. There is also the segregation of principal and interest at an early stage. This is a gray zone. All SMEs that are in problems in terms of liquidity and the banks are running after them or lenders are running after them, they will normally come to us as the experts or the lawyers when they can't even distinguish between the principal paid, interest paid, and penal interest. So it is important that if you're going to engage in any debt, to avoid your shop being closed by a lender, it is important that you engage an accountant from the start, so that you're able to establish principal and interest at a very early stage. I call it a gray zone because everybody who walks in here doesn't know, everybody who walks into our farm normally doesn't know even what the principal was, what the interest that they paid. And then the other is the monster or the demon called penal interest. If you have an accountant, it is exposed from the word go. You know what the penalty is. Unfortunately, penal interest is never elaborate as the amount borrowed, interest payable, and the period or tenure of the loan. So penal is normally in the subsequent clauses towards the end of the loan agreement. And that one is normally a killer. It is compounded, we go to up to 46%. So, and it's compounded on the installment and even on the loan itself. So it is important that you engage an accountant from the word go if you're going to engage in any credit. Taxes or duties payable on the facility or collectible by the lender. A unique one is a lease facility. And I'll give an example. We're in court with a client, with a bank representing one of our clients. And their major contention is the facility that they took out. It was a lease facility. It is unique in that it attracts VAT. So for every installment you pay, you must also pay an 18% VAT. So while you're busy computing your interest payable, there's also an 18% tax that is supposed to be paid on every installment. So the client ends up paying only the principal and interest on the loan, while the VAT still remains hanging over them. Since the duty of collecting VAT is on the bank created an outrageous facility of 1.2 billion after 1 year of running the facility. So it is clear that this loan will never be paid because there are no cash flows matching the 1.2 billion facility of VAT. So if an accountant was hired from the word go, the accountant would be reconciling the accounts on a monthly and also the loan statements and even the agreements themselves. Accountants also read agreements to appreciate how they're going to amortize the loan or facility that has been taken out. So it's important that you engage from the word go, as opposed to having your shop closed because you didn't see the aspect of tax that was embedded in the loan. I will continue quickly because my time is not still available. So why the lawyer? I'm going to make some selling points for lawyers, so please engage us. Key documents will be reviewed and quick solutions. Okay, are we?
No, it's okay. Continue, Kenneth.
Okay, super.
People, please keep muted. And if you answer something, you can raise your hand and then she'll unmute you. All right, continue.
Okay, fine. So I'm making some sales here for lawyers. So why the lawyer? You can omit the debt collector from this. So number one, the lawyer will definitely review the loan agreement at a fee that would save you the stress of being closed. So number one, the lawyer will identify the nature of bank facility, whether it's an ordinary loan, a term loan, a lease facility, an overdraft, or an overdraft. Facilities are many in this market, but all of them are unique in their behaviors. An ordinary loan will have normal principal payable and interest, and the penalty, of course. Then term loans are mainly development loans. These are unique also. They are payable either quarterly, biannual, or annually. So it is important to always have your lawyer to break it down for you that if you're going to pay biannually or annually, start saving the payment on a monthly. So that you know your installment, you break it down into monthly and you save that payment monthly. So that by the 12th month, if it's an annual payment, you can pay. I can assure you that in construction deals, many of them go for annual or biannual. And it is possible that you will forget, concentrate on the construction, concentrate on putting new furniture in the hotel or in the school, and forget to save on a monthly for the loan repayment that falls 6 months down the road. When 6 months are full, the installment is big. It's normally 50 million, 100 million, 20 million, and it's really astronomical for you at that moment to even find that money. It is possible that if you go into the second default, if it's biannual, that's by end of the year, you're in arrears of around 1 billion or even 500 million or even 200. Simple mathematics could have saved you because the lawyer would inform you that on a monthly, please put money aside to pay this thing, or have a transaction that leads you to that payment. These facilities, I've already explained that there's a VAT component. Those are very unique facilities. Also, the asset doesn't remain with you, goes back to the bank normally. So you need to appreciate that at the end of the loan, this asset won't go onto your balance sheet. It will go back to the bank. So you not have any asset portfolio to talk about because the machine might go back to the bank after the lease term of 36 months. This advice can only be sought from a lawyer who's experienced in financial services. The other is an overdraft. We all know it runs for 12 months, so you can take it and sleep and send in a loan, while actually the loan is coming to an end by December. The other aspect, if you hire a lawyer, is you'll unearth hidden treasures of the bank. I call them hidden treasures because that's where the bank makes money. That is penal interest and the rate at which it is being set. The other aspect is the nature of foreclosure mechanism of the bank in the event of default. As you take a loan, also look at the end game. You might pay, you might not pay. So in the event of any default, what happens? Are they appointing a receiver or a liquidator? A receiver will run your business for some time or may strip your assets, but you may get back your entity. It might not close down 100%, or you will have your name. While for a liquidator, it is clear that the person will come, or the insolvency practitioner will come to close you down and also deregister you as an entity registered with Uganda Registration Services Bureau. So they will liquidate you, they will wind you up without a doubt. So some key contracts have these options already embedded therein, providing for receivership, for appointment of a liquidator, a receiver and manager. All those aspects have to be explained to you by only a lawyer. Even if you Google, you might not get the exact practical definitions as domesticated here. What security documents are you signing off? What is the exposure to the company assets is very key. If you execute a debenture, it could be a floating or a fixed. It means that your assets are at risk from day one. It could crystallize on any, including the desks, computers, laptops, and cars. So you need to know what you've executed. Your plant and machinery might be at risk because of a document that you signed that was not even called for. There are some assessments of loans where you're told to sign the following documents, and therein is also a debenture, which is not part of the security documents provided for. But because the legal officer was trying to perform over and above, they produced all the documents, produced a mortgage, produced a debenture, produced a chattels mortgage, a lien on chattels, everything was produced. So you sign knowing that I'm getting money. Is what they call the whiskey throttle. If you engaged in motocross, when you hold your accelerator and you can't stop and you just continue running, and then you end up being stopped by a wall. So the whiskey throttle is all lenders are prone to whiskey throttle when it comes to borrowing money. Money, sign here, sir, is quick. You just sign off anything. You could even sign off your organs to a donor. So standing orders and assignments of proceeds or debts, these are also documents that are normally provided by banks. The implication of these is actually high because it carries an event of default. In the event that you have in your building and you start collecting rent also maybe from 2 apartments, it's an event of default and you run a risk. It's an event of default and you run a risk of the loan being recalled. You need to prompt me if I've gone offline, because I noticed that my internet connection keeps bouncing.
No, we can hear you.
Okay, super.
Right.
So the other is Evans and Sons did not consult an expert. What options are available now? So I'm looking at the Lifelines, what options are available now? Since he didn't consult an expert, so scenario 2 has now stepped in. So the approach, so number 1 is approach the bank or lender when it is still early. When you're in 30 days arrears, 60 days arrears, approach the bank as quickly as possible. Explain your predicament, however tough the bank officer sounds or appears. These people are human, and I speak from experience. They are human beings. They will try to wait for you to try and put your house in order, but also have options. Don't go and talk about how COVID has hit us. There is no money in the market. The economy, you can see it. Those things will not make sense. Explain to the bank why you're in arrears of 30 days or 60 days, and also have a plan on how you're going to pay those arrears and also the subsequent installments payable. So the engagement prepares you for a variation or a rescheduling of your loan. These are normally the outcomes. So the law of contract, since you asked me for Lifelines, allows parties that have entered into a contract, for example, a loan agreement, to change a few terms in the agreement. Number 1 could be interest. Number 2 could be the repayment period. Instead of 36 months, we want 42 months now, because we have a new competitor in the market who's also supplying Niginas. So we need to find new markets. Maybe we're moving into Hoima, which is the oil city. Many people might want Niginas in that oil city. So in all contracts, if I'm not mistaken, there is a variation clause, and it's normally worded under nothing shall be added to this agreement unless both parties have agreed. It is important that that clause is added into the loan agreement so that you have a lifeline to apply to vary this contract if there are any unfair terms or market dynamics have changed, like COVID. There should be an opportunity to vary that contract. Whereas the law allows you to vary, but also having it in the contract is very good. So whenever you see that clause, nothing shall be added to this agreement unless both parties have agreed, just know you have a lifeline in terms of varying the agreement. But that variation only happens when you're in a discussion with the entity that has lent you or the lender, and you're providing a way on how you're going to meet your repayments. So as you negotiate, have your accountant and transactional lawyer by your side. Why? Engage an accountant to prepare a receivables report. In other words, show your cash flow, show who owes you money and when to be collected so that you can pay to the bank. This is where assignments come into play. If you have debts that are repayable and are scheduled, and you know that they are consistent, you can assign these debts to the bank and say, no, we have stock of so much that is out in the sales teams, but we have agreements that they pay us every 45 days or 30 days. These are lifelines for you to renegotiate or have a variation in your repayment plan based on when you are paid. If you've supplied Carrefour or you've supplied Hoima in the oil city, their payment terms are 30 days from delivery, then the bank will have to listen to you. There is no shortcut. If they fail, the lawyer will know what to do because there is already a plan to pay and the cash is in the future. So engage a debt collector immediately or create targets for your sales team. That is your sons, that is for Evans and Sons, to aggressively collect all unpaid debts. Look within before looking for solutions outside. Why I say this, I know of a bank in this town where every person who disburses a loan also has the responsibility of collecting it. So in other words, whoever supplies these nigginers in the market should have a responsibility of going back to collect the money because cash is king. Scenario 2, Evans and Sons has failed to hit all demands and the last demand has been served. Way forward. This is where now things have become tough. You have failed to find an alternative. So there are three options. A quick review of the securities pledged, and I advise this very often that solutions are within before you look outside. So a quick review of the securities pledged if the bank is oversecured. Quickly propose a disposal of part of the securities and save the business. This is one lifeline. Enter into an agreement with the bank, vary the securities that were pledged, because oftentimes the bank will never lend you unless your security is over and above what they are lending you. So in my view, they are oversecured at all times. If it is land, subdivide part of it. If the apartments, create condominium titles, sell some of them. So for every security pledged to the bank, as an SME or as a business owner, have no emotions towards it. Just know that one day it might go. What you pledge is what redeems your business. So have a mentality of this thing could go. Do not say it is my thing, my judge gave it to me, it does not happen. Subdivide, remove the VJ alone, and then sell the other part and save the business. This is an issue of you save the child or you kill the mother. So in my view, you need to sever this one and say, okay, fine, this I will let go, I'll keep my business going. So if the bank is not agreeable, with the help of your accountant and transactional lawyer, prepare a good story on the numbers. Normally, all proposals that are made are stories of how the business has thrived for the last 48 years. It is a family business. It's called Chapambalasi, so it has lived forever. Unfortunately, when you're in debt or when the liability has now become due for collection by the lender, it is important that you create a story on the numbers mainly. So your accountant is very key in creating the cash flow projections, whom you've supplied, who has to pay, what are the markets, what's the market presenting to you? Do you have any business partners coming on board? That story has to be told. So a business case scenario must be made. For number one, refinancing from another lender. So this business story is made for another lender that could take on the loan so that your door can still remain open. But that business case scenario should not be a lie, it should be actual, one that can be realized. Otherwise, your next bank or lender where you go for refinancing will see through and say, this is a lie. I had a task of looking for financing for a farm, and we had made a business case scenario of how many cows can be slaughtered in a day, in a month. And when the lender went down there, look at the number or the herd that we had, it could not speak into the projections that we're making of slaughtering 400 animals in a month, supplying them to the following entities. Yes, we had contract supply, but we had no animals on the farm. So the lender was quick to reject our proposal for refinancing. Venture capital funds, these are available, but very hard to get in Uganda. Recently, I attended a training or a conference for the International Insolvency Practitioners, INSOL, in Rwanda. And one thing that I established that number one, funds are available, even for Africa, from the funders, from the venture capital funds. The only issue is ticket size. How many lenders do you have in your country that can take $30 million? So the lending cap is $30 million. That's the lowest. So in other words, you're looking at putting together all manufacturers in this country and asking them to apply for the venture capital fund to fund their capital inadequacies. So in Uganda, it's a bit difficult to secure a venture capital fund, but it's available. In Nairobi, it's available as well. But the issue with Uganda is the size of the entities that they are lending into. So as an SME, it might be very difficult to get this money. The other option is invite new shareholders. Businesses must grow. You must live away from Evans and Sons to at least becoming Evans and Sons Limited, so that you can invite new shareholders. So proprietorships are being discouraged, I think, world over in terms of doing business. So invite new shareholders who could become your equity partners, because whoever comes on board brings some money. Sell some equity. The other is float new shares. Your lawyers can help you on that. Create preferential shares. These are for family and friends, because you don't want family and friends to keep in your business. So they can lend you and you give them preferential shares. Upon payment, these shares are redeemable by the company. So these options are available in terms of in-house borrowing as opposed to going outside. So there are friends that associate with you who have money. There are family friends, their family members also have money. They can lend you and get preferential shares. You need to sell to them the aspect of hold these shares as security, but I'll pay you back. Grants or aid, I'll tell you that it's unbelievable that there is funding in some sectors. So you need to position yourself for that funding. There's regional positioning. For example, the old city in Hoima. 2 weeks ago, I attended a breakfast organized by Southbridge from London. It's a company that has been contracted by by the French company Total France, to put in place 100,000 jobs by end of this year. I couldn't believe it. And if you put the jobs in place, you automatically qualify for a grant in respect to the jobs created. Whether it's $1,000 or 10,000 or 30,000, if you create jobs, they will fund the jobs. So farmers have been excited because the sectors are farming mainly, and value add entities. So if you're in that value chain, you definitely qualify for funding, but you must create the job. So grants are available, though this information is not made public. I know that Public Sector Foundation also has some funding, and it's for SMEs. So we do qualify. The only issue is we have no knowledge of some of these things, and they pass us by, so we struggle. I represent an entity that deals in beef. I'll shock you that actually this entity thrives on grants and venture capital fund. People actually do invest in these entities as long as your business plan makes sense. You're showing how you're going to impact the community. You're into the sausage business. You're going to sell sausages on the streets. You're subsidizing them for the street sausage roaster. And people have around $4 million given to them to run this project, to create kiosks. Whenever you see kiosks running around that look like they are modern bimezas, just know there's funding for that chimeza wherever you see it. Unfortunately, we don't share information as SMEs. Maybe on this platform you share. Scenario 2, continued. Still, we are in a position of being indebted. When the going gets tough, I think we all know that saying or that slogan. When the going gets tough, you now look at other alternatives. Unfortunately, these alternatives would make you or kill you. So there's protection under the insolvency laws. So we have the Insolvency Act and the regulations. It's a regime that takes care of entities and individuals that are delinquent or those that are heading towards insolvent or bankruptcy. money has become an issue and you need to, your creditors have surpassed you in terms of even maintaining them. So one of them is an arrangement. That's arrangements for individuals, that's sole proprietors. If there are any SMEs here, if life gets tough, there's an arrangement. The debtor must apply to court for an interim protective order. So you must get a lawyer to apply for an interim protective order, which protects you against your creditors, the banks, the landlord, the school fees guy for your children, the guy whom you supply, the guy whom you owe for all your supplies, for example, all your raw materials. If it's Evans and Sons that make Nigina, the guy who supplies those chemicals that convert the powder into rubber. So all those are after you. Unfortunately, this expires in 14 days. The other aspect is you need to quickly engage and appoint a supervisor while you're under this arrangement. So it's for court to actually allow you headroom after the 14 days have expired. So your lawyer will know the dynamics of extending an interim protective order. He will know how to organize the meeting of creditors. He will advise you on how to move away from the interim to the real protective orders being given unto you in terms of an arrangement, where you enter into an arrangement with all your creditors and you agree to pay them within a specific period and matched with certain cash flows. The challenge is the supervisor takes over your affairs. So you have somebody who takes over your affairs. You're more or less incapable of taking your own financial decisions. So the supervisor will supervise you on how you execute your business going forward. So Evans and Sons will be under a supervisor for some time to ensure that all the suppliers are paid, those who supplied raw materials. The tax liability has been paid to URA, the bank has been paid off, and all their creditors. The challenge is if you are unable to meet or to comply with the arrangement, you will definitely be adjudged bankrupt, unfortunately. And please note that any creditor can apply to court to have this arrangement terminated. If you've not paid them even one installment, they will apply to court to terminate this arrangement, so they adjudge you bankrupt. The other is administration for companies. For companies, a provisional administration is provided for under the law. The only challenge you'll have, public notice will be given to everyone that this company is broke. So they've asked to go into administration. If you read the papers, there are two companies already that are under administration. I think one was successful, that is UTL. Successfully, it went out of administration. It is believed to be profit-making now, or at least it can pay its, it's not profit-making, but it can pay its liabilities. There is another, I will not mention, because the matter is still in court. It is a coffee entity, and it is also under administration at the moment. And there's a reorganization. One of the biggest points that they are trying to put forward is that they have an equity partner who's coming on board, and the other also is a venture capitalist who's coming in to inject money. Now, the challenge is that proposal has to be accepted by the creditors. They might reject it because bringing a venture capital on board or an equity funder, it means they're going to take equity into the entity. They might be only financing capital and not financing repayment of these debts. So those are issues to look into. Your accountant will definitely help you to do the projections to see if the funding of capital will actually increase your sales that you're able to pay your creditors. Directors and secretary powers are suspended immediately. So those are also repercussions. Evans and the wife and his two sons will cease to have any dealings. If Evans and Sons is a limited liability entity, they'll have nothing to do with the company to be taken over as it is being monitored. However, whoever takes over the company in administration, the insolvency practitioner has a right to, has powers to actually allow the directors to operate, but with minimal powers under his supervision. The last and final remedy, which I would not encourage, is injunctions to stop the recovery. Why I don't encourage this is that it puts the lender into a position of it is now fighting mode. We're now ready to engage bare knuckle. And if it's a mortgage facility where you pledged your security, we have Regulation 13 of the Mortgage Act that says that unless you put down 30% of the amount outstanding or 30% of the value of the market value of the property, you cannot challenge the recovery of a debt by a lender. So immediately you're knocked out on a technicality. If it is a receivership, you may have a lifeline in terms of going to court. If it's a receivership with no property under the Mortgage Act, you may succeed because there's relief. And our laws, that's the Judicature Act. It allows you to apply for an injunction to stop a sale or a recovery of an asset of an entity that is delinquent or that is in default. You may have objections on interest and the like. So those are remedies that are available. But I need to caution you that this is just buying time to put your house in order. If you go for an injunction, you need to look for the money. The problem is yours, nobody will sort it out. The cub has become a lion, it's going to eat you. Ladies and gentlemen, I end my presentation. Apologies if I've overshot on time.
No, thank you very much, Kenneth. This was quite interesting. Interesting, I just remember the scenario where there's a certain business sole proprietor who had gotten a mortgage on their property. They had defaulted for a few months and the bank was threatening to dispose of the property in order to recover. The proprietor then got into a discussion with the bank. What if to find out if they could get a buyer, which they did. And the price the buyer paid, 50% was taken by the bank to recover their costs in totality. And the entrepreneur remained with an additional 50% that helped them to reset up and start again some other aspects of their business. So these are remedies that are very available for people. Any questions? There's a comment here from Caroline says, thank you, very insightful. Emmanuel also saying good hearing from you. Any questions or comments to Kenneth? How does one get there to, Kenneth, maybe could ask, how does one start the conversation with a bank or with a lender in case of payments delaying?
Okay, as I presented earlier, the conversation with the bank is, number one, when you walk to the bank to borrow money, you engage the bank. You did not just get the money off an ATM and it was there. So in my view, the way you started is the same way you should also start. Number one, you have a relationship person in the bank. The person who wrote down who collected your paperwork should be the person that you engage. Number one is your first line of communication with the bank. Your relationship manager will help. They're always willing to help. I know they're looking for the next deal, but also want to lend you again because you're a repeat customer. So they hit their targets easier if you're doing good in terms of the bank.
Okay. There's a question from Iga. Zenola, please go ahead. Zenola. Hello.
You might have to unmute him.
Thank you. The host had to allow me to unmute. Thank you for allowing me to unmute.
All right.
Thank you, sir, for the presentation. Two questions. Recently, there was on social media a video of a lady in a bank, maybe that I shouldn't name, or maybe I should name, and she is lost her cool, and she's saying, I've been coming to this bank for 4 years now. I paid the debt. You had changed my title to someone else's name. You had no right to do that. But anyway, that was settled. I paid the debt. And for 4 years, I've been coming to get my title. I now want my title today. The thing is, what can one do to the bank? I know there is a lot that one that the bank can do to one, but what can one do to the bank? And relatedly, I mean, in terms of the bank many times using their elephant size to squeeze the rat. But relatedly, there used to be something called the arbitration center. I see, there's supposed to be an arrangement where there are arbitration services. I'm thinking in Uganda, we have not yet gotten to the point where one can easily get compensated. But I'll give the example of that. And also you go to the bank and give a standing order. And when you go back later and say, I now want this standing order changed or revoked, and you even put it in writing like you did in the first place, and then you discover 6 months later that they've actually continued to remit what they should have not been remitting for the last so many months. And you feel aggrieved. It's not just a question of the money, but also the inconvenience, the agony. Where are we as far as arbitration and compensation of the client vis-a-vis the bank in this case? Thank you.
Thank you. Maybe Kenneth can also.
Mr. Were, can I respond to him first?
Yeah, that's okay.
Okay, fine. The first issue, the lady who lost the title. I represent banks. I wanted to know which bank is that. But even if I don't know the bank or whether the bank is my client, I think I can give protected advice, hopefully. I'll ask my lawyers whether I still have any protection. But one of the remedies is number one, put in writing. Social media will not avail you a solution. Maybe it will get the bank to move faster, but you're among the statistics of those who make noise. So in my view, you need to engage a lawyer. Number one, put in writing, make a demand for the title to be released, narrate your story. Number two, if there is nothing that is happening, you report to Bank of Uganda. There are consumer protection regulations that are in place, that if a customer is not serviced well, they have a right to report to the regulator. Bank of Uganda is the regulator, so you can lodge your complaint, and the bank will be brought to book in terms of what has happened to the title and whether it was transferred or whether it got lost. There are remedies even when a title is lost. You can apply for a special to be put in place, of course, at the cost of the bank. The last resort would be to go to court. Lawyers know what to do when they go to court. They will definitely demand for damages, for lost opportunity, inconvenience has to be compensated. So that will be handled by the lawyer. There are remedies, because I won't say that we've argued cases, but we have argued cases, yes, for lost titles as a firm. Standing orders in place, I'll still refer you to the consumer protection regulations under the BOU. This you can also take them on with the regulator, because banks don't operate like elephants, as you say. Yes, they're elephants, but they're also regulated. So they have a regulator. And any complaint under these regulations is actually taken seriously. If it's not heeded to, you definitely can still engage an expert, that's the lawyer. The other aspect is as arbitration. Arbitration has grown in Uganda, I can say for a fact, because I'm an arbitration practitioner myself and also an arbitrator. So it has grown. Number one, we have KEDA, the Center for Dispute Resolution, which is situated at the Commercial Court. It's still available, because it was created under an act of law, an act of parliament, so it's available and still open. The other is ICAMEC, the International Center for Arbitration and Mediation in Uganda, in Kampala, which is also in Uganda. That is also available. The other, ad hoc means that if you have an agreement that the matter shall be referred to arbitration, then you can appoint any arbitration practitioner. So our courts are very emphatic these days. They enforce awards that have been made by arbitrators. So the other encouragement I can give you is when you're negotiating any agreement, you could insist that the bank puts a clause as to arbitration. They might be hesitant, but at times they will agree, especially if you have if you have good bargaining power in terms of you have good cash flows and things like that. But normally banks are hesitant to change their templates. But I know the banks are actually moving to arbitration. I'm aware that ICAMEC, the banks did support its opening up with the hope that they would resolve all their disputes through arbitration. I'll give you an example of the construction contracts are standard now. They all have arbitration clauses and adjudication clauses. So in other words, their disputes are resolved faster. Some are even decided within 2 weeks or 3 weeks. So it is possible that our market is also driving there in terms of the banks for arbitration, because their cases also lag a lot in court, so they take some time.
Okay.
Mr. Zinono, I hope I've answered you.
All right. Yeah, I think it's muted again. There are 2 questions in chat. Yeah, Mr. Zuna says he has been answered. There's a question from Arthur Kateva and from Ronald. Now, Arthur Kateva says you've outsold yourself. His question is, do lending facilitators give ample time to potential borrowers to review the loan list terms to allow their owning entity to review and give you advice before you procure a loan? And then the second one, is in case you have to liquidate a property to pay a loan, who takes the lead in making the sale? You can answer those 2, then we shall give Charles a minute to also ask his question.
Fine. I'll start with the liquidation. Mr. Kateva, the liquidation, who takes the lead? Every time you approach the bank with a proposal of paying their money, they'll listen to you. So if you put a property on sale, you're free to tell the bank also to find buyers for the same property. They could even facilitate and help you advertise it. Also give it to their bailiffs who help in selling their properties of distressed clients. So the lead, in my view, it's a joint normally. Whoever brings the buyer and the money is right, the bank is willing to accept it. And you are willing to accept it as Kateva, as the borrower. If you're willing to accept the amount that is being paid, then the bank is willing to take it. If there's a balance, of course, it will go back to you. So in terms of who takes the lead, both of you can sell the property. Banks welcome repayment plans. Time to review the contract. You have a right to ask for the contract, to go and review it with your lawyer. Fortunately, these days, most of the contracts require for a lawyer to witness at the back. What normally many borrowers do, because they are quick, that's the whisk throttle. They are quick to sign the documents. They'll even drag the lawyer to the bank to go and sign. In my view, you should be able to take the documents. Say my lawyer cannot come to the bank today or even tomorrow, but if I took them to his office, I'll get him early morning. So that way you're allowed to take the documents out, and then you can give them to your lawyer to peruse for you and highlight for you which clauses are actually detrimental to you. And even if you may not be able to change, but at least you're aware that there are these demons like penal interest that is waiting to bite you. So it's a tact that you need to develop, asking for your documents. It's a right that you have.
Yeah, that is very important. A lot of entrepreneurs make a mistake. They do not review contracts before they sign them. Especially they're like, this is a bank, they have my best interests at heart. Sometimes also the banks, these contracts can be developed by people, and people do make errors. So there could be something in there that's not supposed to be there. And when you review it and you don't understand it, give it to your lawyer. Even when you understand it, give it to a lawyer or your lawyer to review and tell you how it could affect you. Entrepreneurs tend to be hard-headed. Like, no, I know it. I said my business by myself. This is like, no. When you're in certain categories, when you're dealing with any contract, always have a lawyer to review it for you, and never drop your own contract. You don't have the information to do so or the expertise to do so. There is Charles Lagu. Your hand is up. Please unmute.
Yeah, thank you so much, Bid. And thank you, Kenneth, for guiding us on the legal lifelines for SMEs. My question is on valuation for security like land in order to obtain loans from the banks. So most times it is the banks that gives you the valuer to come with the value of your, for example, land. And I see that there's a gap because, for example, your land can be like, say, 150 million in your own assessment and market. But it is most probable they can give you either 80 or even 90 million, which means that affects you to get the ultimate amount from the bank. So from your perspective, how do we close that gap? Because they cannot allow you get your valuer and get a valuation report, they have theirs. And therefore you find that as a client, you are powerless. So from your experience, now that you have told us even you work with the banks, how do we close that gap? Because for me, I see that's a very, very key gap in the whole process. That means I will get less money than I should have got, and I cannot grow the business. I thank you.
Okay, fine. Can I go?
Yes,
Mr. Wade?
please.
Okay,
Yeah.
so Charles, two things. Number one, the bank doesn't trust your value as well. Because the possibility of your valuer answering or dancing to your tune is high because you're the one who's paying. So you're likely to convince the valuer to give your land a higher value. If it is if it's in Choga and it's 100 million, you say it is 250 million, so that you can access a loan of 150, the value of the land itself. So it is probable that you will convince your valuer to give you what you want. He who pays the piper, I think, plays the tune. So the bank will not allow. The other safeguard that you have is the bank retains accredited valuers, I must say, who will value the property, yes, in the interest of the bank, but also in the interest of getting the real market value and for sale value of the property and insurance value, so that there is no loss. The other aspect is these valuers do actually take out indemnity, that in the event that they have they've given a wrong valuation, overvalued or undervalued the land, they are supposed to compensate the bank in case there's a shortfall on recovery. So the bank has to safeguard its money first before it can think about your valuer. But in the event that you feel that your land has been undervalued, you are at right and at liberty to actually take out an independent valuation on your own, which you can put to the bank and say, but my land is 300 million, not 150 as valued. And there are mechanisms for reconciliation and the actual value of the land. So the two valuations are put before the two valuers and they agree on what parameters each one of them has used. Valuation parameters are quite standard and they are known. So one can't arrive at a different figure, then another also at a different figure. There are market forces also that play. Market value is known, so brokers around can tell you how much your land is, but also the other factors that come into discount your land is a wetland, this, that. So you may have your own value as a borrower, but unfortunately, the valuer will give it its real for sale value and its real market value. We are not experts in that area, so you'd have to have some faith in the expert. Yeah. I hope I've answered Labu.
Yes, I hope so. Usually clients overvalue their property and sometimes banks tend to undervalue. So maybe having a mid ground is good. Kenneth, you mentioned grants and opportunities that are there. Usually we have partners coming to us as enterprise, those coming to the market in Uganda looking for people to work with, but people just don't have the information. One thing that Kenneth mentioned is having an accountant to go through your books. A lot of entrepreneurs do not have good books, so they're unable to qualify for some of these facilities that are there. So people usually ask for you to get a grant, what is your sales figures, and most people do not know that. And when you're asking for advice, please get advice from people who know, not from people who you be with at your local, or sometimes you are within church. Just because you're with that person all the time, doesn't mean they're qualified to give you the right advice. Look for somebody to give you the right advice basing on that. Any other questions? We are going to close. Also, Enterprise Uganda will be refining our database soon. So we shall send out a survey asking you to give us a bit of information that can help us match you with partners and opportunities as they come along. We have a few that are already in place, but we don't have enough information. So we shall, in case you receive an email from us next week, please do reply and just give information that will help us to match you with opportunities as they come along. Thank you very much, Kenneth. Kenneth, in case somebody wants to get in touch with you, how do they find you?
I'm situated at Lowdale Tower, 6th floor. Amber Advocates. You will not miss us.
Okay.
In terms of phone number, it's in the chat, and my email is there also.
Okay. Please do post in chat again for people who have just joined. They may not have got it. We shall be sending out a recording of this session. And in case you have missed this, you can go to Enterprise Uganda YouTube page and subscribe, and you can look at all the previous recordings and any future recordings that you'll miss. Also, we do update on our LinkedIn and our Twitter and our Facebook. I shall hand over to Ronald. Give a thanks to Kenneth. Ronald?
All right. Thank you so much, Abid. Kenneth, thank you so much for sharing with us. We are very honored having you on this session today.